Good morning, and thank you to everyone for coming to this morning's webinar on OSHA's Vaccine and Testing Emergency Temporary Standard, what we'll be referring to frequently throughout this morning as VETS. There's been a lot of different rules coming out from OSHA, but this morning's webinar is on the vaccine and testing mandate for 100 or more employees. And that is what we're going to be talking about today. So before we dive completely into the content, I just want to acknowledge where we are at this particular point in time. We've got the first question at 8:01, which is the question on everyone's mind. What does the Fifth Circuit's decision over the weekend mean for us here in Michigan? With not even a full day on the books, the Fifth Circuit, as many of you know, temporarily stayed enforcement of the Biden administration's ETS. That does have nationwide implications. So for the moment, the ETS is on hold. And you may be sitting here saying to yourself, well, why am I here? What does this even mean? But sit tight. We're going to get into all of that because it is only a temporary stay, and we're waiting for more information today and tomorrow. Additionally, over the weekend, the Department of Labor has said that they're going to be issuing some additional guidance on the ETS. So what we're presenting to you here today is what we have as of 8:03 Monday morning, November 8th. And as always, we'll keep you informed and updated as we go forward. So what I want to do is first make sure that we are all on the same page about what we are covering today. So this morning's webinar is going to talk about the breaking news over the weekend. We're going to delve into that. I'm going to tell you a little bit more about what it means and what we can expect this week and in the coming months. Then we are going to dive into understanding the ETS, because if this stay is lifted and the ETS is allowed to go forward, we're going to be on a much shorter ramp-up period than we ever were before. And then we're going to dive into your questions and answers. We received over 100 questions related to this ETS, and frankly, we still have some questions ourselves too, which is why the Department of Labor is going to be issuing some additional guidance. But there are some frequently asked questions that we've got some answers for, and we'll get to your questions that you're submitting live this morning as well. So I'm here this morning with my co-presenters, Brett Swearingen and Sandy Andre. So first and foremost, as we said, we've got breaking news here this morning. Republican governors and attorney generals from over 20 states filed lawsuits immediately when the ETS went into effect on Friday. Now, that had the impact when the Fifth Circuit ruled of halting temporarily the implementation of this order. The Biden administration has to submit briefs on this particular issue by 5 p.m. today, and then the petitioners have until Tuesday to decide. From there, the Fifth Circuit could decide to permanently enjoin or stop the order from taking effect, and then we'll see if it goes up to the Supreme Court and the Supreme Court weighs in on this standard. If the panel on the Fifth Circuit decides that they don't want to continue to temporarily halt this order, then the ETS will immediately begin to take effect again. And the million-dollar question is, are we going to get those days back from the ramp-up period that we saw? And we don't know, but that's an issue that we're paying very close attention to. So, for now, it's on hold, but we advise to continue to know what the rule is, what you will have to do, because your employers and your decision makers in your organization are going to have these same questions of you. So we're going to give you all the information that you need today to arm yourselves with answers to the most pressing questions that people in your organization are going to have. Information is power. Understand the rule, stay informed, be ready to act, and we're here to help. So today we're going to go over the basics, the who, what, when, and why of the ETS. And then, as I said, we're going to get into your questions. So the who. Who is and is not covered by the ETS. We can see, so many folks chiming in here. What does it mean? How do we calculate these 100 employees? It's very good. OSHA has issued an FAQ, which has a section of probably, 10 questions specifically related to this. We'll put that in the chat later today, so you all can have access to that document as well, but we're going to be going over those frequently asked questions today. What does the ETS require covered employers and employees to do? So say you are a part of this rule, is there any option to not get vaccinated? What is this testing component? We're going to go over that. When do we have to do it by? And then why? Understanding the penalties for non-compliance, which can be pretty severe. So with that, I'm going to hand it over to my colleague, Brett Swearingen, who is going to walk us through the who. Thanks, Brett.
Thanks, Hillary. So there's two big things OSHA is trying to do in this current ETS. One is protect employees that they believe are in grave danger of contracting COVID and suffering serious consequences from COVID. And the other thing is they're trying to limit this rule because they do understand how much burden they're imposing on employers, at least to some extent. They're trying to limit the rule to employers that have enough size that they have an HR apparatus that could handle implementation. And so how they're doing that second piece is they're limiting the rule to employers that have at least 100 employees. Now they're defining 100 employees very broadly. It's basically 100 employees of any kind in any state across the US, whether or not it's 10 locations, 1 location, 100 locations. But you need to have at least 100. You need to have 100 at any point after the rule went into effect. So at any point after Friday, November 5th, if you have 100 employees, you are now covered, even if your head count dips under 100 going forward. Once you get under the coverage of the mandate, you stay under the coverage of the mandate until the mandate goes away. 3 big chunks of employers who are not covered by the mandate is employers who are otherwise covered by another federal mandate or regulation. The first one I want to mention, because I think it's kind of viewed by the federal government as top of the pyramid, is the CMS mandate that was also released Friday, or published Friday, released Thursday. This is a vaccine mandate that applies to any employer facility that is participating in the Medicare or Medicaid program. And if you are in that bucket, you have an even more stringent mandate. There is no testing option. It's a big difference. Anyway, if you fall under that bucket, you do not have to comply both with the CMS mandate and the OSHA ETS. The second big one, I'm sure some of you on this webinar are included in, is the federal contractor mandate. That is kind of first out of the gate. It started in September. There's already been all kinds of implementation. If you're covered by that, or at least if a workplace is covered by that, this could get complicated where you have some workplaces that are covered by, say, the contractor mandate and others that are not, and in which case the non-federal contractor covered workplaces would also be covered by the OSHA ETS, assuming as an aggregate you have 100 employees. And then if you go back to this summer, OSHA put out a healthcare ETS in June. Just like the others, if you are an employer who is already covered by the OSHA healthcare ETS, you do not also have to comply with this ETS that came out Friday, again, assuming that it goes into effect at some point. Now, when OSHA says that they're trying to protect employees in grave danger, what do they mean? Basically, they mean any employee who might come into contact with another person who is not a member of their household indoors. So if you do not go to a workplace where there are other people present, you are not covered. If you only work from home, if you telework, you are not covered. And if you only work outdoors, and OSHA is very clear, they mean only work outdoors, as in you don't share a car with someone, you're not a construction worker who spends break times in the trailer, you also are not covered by the mandate. So just to go into more detail on how they're counting 100 employees. Again, it's very broad. It's 100 employees at any point after Friday, anywhere in the United States. So part-time employees count. Volunteers do not count. They have to be actual employees, so a volunteer would not count. As I said, so the second bullet, part-time employees do count. Volunteers would not count. They're not actual employees. An independent contractor is actually not an employee, so they would not count. Again, if you have multiple locations, you need to combine all locations as long as it's in the United States. Those employees need to count. In terms of franchises, you count separately for the franchisor and franchisee. So an independent franchisee would have to do his or her own count to see if they have a combined 100 or more employees at all of their locations. On the other hand, if you're the franchisor, all the corporate staff of the franchisor would be counted separately to see if they hit 100 employees. In terms of staffing agencies count their own employees whether or not they have employees off with clients. Similarly, if you are a client who uses staff work from temp agencies, you do not count them, you count your actual employees. So if you have a staffing agency that has more than 100 employees and has 5 at some work site, and that employer only has 50 employees, the employer would not be covered, his or her employees would not be covered, but those 5 staffing agency employees, because the staffing agency has more than 100 employees, they would be covered. So it gets a little bit complicated, but the general rule is determine your entity. If it's an employee anywhere in the United States, you're covered, and you stay covered until the mandate goes out of effect.
Okay, good morning, everybody. I will talk us through what. So you've made it through all of Brett's analysis, and you figured out if this EPS applies to you, how to count your 100, and if you're over that threshold. So say it does. So then what? What do you need to do? The requirement is that an employer adopt a policy, and the employer has a choice of what kind of policy to adopt. In OSHA's view, they call one a mandatory vaccination policy, and the other they call a partial vaccination policy. So let's talk about the nuts and bolts of both of them. Next slide, please. Let's first start with the mandatory policy. So under a mandatory policy, the only employees who are not subject to mandatory vaccination would be those who fall into specific exempted categories, okay? So all employees, unless they fall into one of these categories, must be fully vaccinated. And those exceptions are if an employee is unable to receive the vaccination as a result of a medical contraindication or medical necessity requiring a delay, or those entitled to a reasonable accommodation under federal civil rights laws due to disability or sincerely held religious belief. So for those on the call who have been contemplating vaccination policies since the COVID vaccination has come out, or even before COVID and you had a mandatory influenza policy as an example, you know that there must be a pathway for reasonable accommodations for disability and sincerely held religious belief under the ADA and under Title VII. So those exemptions did not go away as a result of this EPS. So the employer must still provide that pathway. Okay, so the employer must follow the OSHA-approved guidance on determining and maintaining records of employee vaccination status, right? So to know if you're in a mandatory vaccination policy, right, and an employee is permitted to not get vaccinated only if they fall in one of those 4 categories, the employer has some obligations to be collecting records related to employee vaccination status and ensuring that the only individuals who are exempted from that policy fall into one of those 4 categories, right? So those pieces all go together, and that's really important. Now, additionally, employers have a kind of paid time component, okay? So for employers who are choosing a mandatory vaccination policy, it's important that they provide compensable time if during work hours for an employee to receive the vaccine, right? And so if it's a 2-dose series, right, they get compensable time for both of those shots if it's during work time. And they are provided time off to recover from side effects after each of those vaccination doses. As Hillary mentioned, right, we are eagerly anticipating some guidance from the Department of Labor specifically on some of those compensable time and paid time off components. But as we read it today, it appears to us that if an employee is receiving their vaccine during working time, that is compensable time. And so that's how we're moving forward until we hear different. But we're relatively sure we're going to hear from the DOL on that, so no worries. Next slide, please. Okay, so if you don't choose option number one, right, if you don't choose the mandatory vaccination policy and you choose a partial vaccination policy, what does that mean? So under the partial policy, right, employers can choose, employees can choose whether or not to be vaccinated for any reason. They don't need, if an employee wants to not be vaccinated, they don't need to articulate it's for one of these 4 reasons. It can be any reason, right? So it's kind of an employee choice. But in that situation, in either policy really, those who are not vaccinated are subject to testing and face mask requirements, right? And so the only exception to that is if employee works in a job that is not subject to a vaccination requirement, right? If the employee is working outdoors or working remotely or not working with any other individuals, just as Brett was saying just a few minutes ago. So the either way, right, you're going to have to build in this testing component and a tracking mechanism for all of that. So what that looks like. So employees who report to work at least once every 7 days where other employees are present must be tested at least every 7 days and provide documentation of test results no later than the 7th day following the date which employee last provided a test result. So that's a big mouthful. We've already gotten a lot of questions saying, hey, can I make Tuesday everybody's testing day and I've got to get results by Thursday so I can build in the delay and time and all those things? Yes, an employer can kind of pick that cadence based on the logistics that make sense for their specific workplace. And if you are an organization with facilities all over the place, as an example, and Tuesdays works for one facility and Thursdays works for another facility, that's totally fine. You as the employer can provide that direction to say, hey, Sandy Andre, right, your last name starts with an A, your testing day is XYZ date, and your results day is XYZ date. You can do that. You also don't need to put that many logistics to it, right? You can put the onus on the employee to make sure that they're testing at that cadence and providing you results at that cadence, but you've got to balance that, right? You've got to balance, we're not permitted to let you in the workplace, right, if you aren't providing us that documentation on that, at least on that schedule, but we also need to staff our facility. So it's this balance of a lot of the onus can be on the employee, but as the employer, you need people here. So that's one of your decision points as you think about how to implement this, okay? So remember, the ETS does not require or prohibit employers to pay for any costs associated with testing. Now, like we were talking about with vaccination, we are anticipating Department of Labor guidance specifically on that paid piece. As we look at it today, right, if that testing, if you're in a facility and you're going to do on-site testing as an example, and you know, in my tiny brain that maybe takes like 5 or 10 minutes, and so you say, Sandy, today, you know, today is Tuesday, that's your testing day, go down to wherever that's going to be, and you know, stand in line and get your test, and that's all set, right, and that just takes a couple of minutes, and that's during my normal work shift. That's likely to be compensable time, right? But if it's off-site or off-shift, that's not, right, as we look at the FLSA today, that doesn't tell us that that's likely to be compensable time, but obviously that is something that we're definitely watching for you all as well, because we understand that that's a huge consideration. Next slide, please. So as I mentioned, either way, right, you're a mandatory vaccination policy employer, you're a partial vaccination policy employer, either way, you have obligations to implement this testing protocol and require face masks for all unvaccinated employees. You've got to maintain records, right, of the test results and vaccination status, and you've got to maintain those records as medical records, right, confidential medical files. So you may know that OSHA has an existing standard related to employee medical records. We've actually done a webinar specifically on that standard, I think last summer of 2020, talking about that. Because of the COVID pandemic, there may have been an opportunity for you all to be collecting employee medical records as a result of the pandemic when you ordinarily wouldn't have. So under that standard, if it meets the threshold of an employee medical record covered under the OSHA standard. Those records actually generally have to be maintained for a term of employment plus 30 years. That's a really long time. Thankfully, hopefully we did not just lose anyone on the webinar when they heard that time frame. Thankfully, this ETS says, hey, employers, you have to maintain them just like they were medical records covered under this existing standard, but you only have to maintain them and protect them for the duration of time that this emergency temporary standard is in effect, right? So that term of employment plus 30 years, that is not on the table at this point. It's just the duration of time that the ETS is in effect. So that's good news. And then of course, right, so you pick your policy, you build in your testing logistics, but either way, you have an obligation to make sure that your unvaccinated employees do wear approved face coverings while they are in the workplace. So that's a little bit of the nuts and bolts on the what, right? Once you find out if it does apply to you, what is it? It's picking your policy and building in the testing protocol and building in the records management and building in the compliance monitoring related to face masks. And I will turn it back over to Hillary to talk to us about when.
Thank you so much, Sandy. That was great. So I'm seeing a lot of questions too here in the chat that I just want to address. You know, for now, again, just to reiterate for those who are maybe joining a little bit later, I'm seeing a lot of questions about the Michigan implementation. Michigan is a state plan state, and the word that we are getting from OSHA is that they plan to adopt verbatim the federal rule when and if it ever goes into effect. So with a state plan, those state OSHAs have the right to adopt their own plan that is at least as protective as the federal plan. Our understanding from talking with our folks at OSHA is that OSHA plans simply to adopt verbatim, the words that they're using, this rule. So what we're talking about today will look like what the Michigan plan has, again, when and if that ever goes into effect. So let's talk about the when. Some of these dates are really important to pay attention to because the ramp-up period is so short. So by December 6th, okay, so December 6th is the deadline in the rule. We've seen a number of news reports saying, December 5th. Note that you have to be in compliance by December 6th, 2021. Employers must be in compliance with all the requirements except those related to the testing protocols. And employees who are not fully vaccinated must wear masks in the workplace. So that's coming up. That's the 30-day ramp-up period. By January 4th, employees must be either fully vaccinated or be in compliance with the testing protocols. And here's an important note. In the ETS, there were some guidelines around when and if the Assistant Secretary asks for records pertaining to a particular business. We're going to talk a little bit about some of the why and the enforcement protocols, but when and if there is an audit, there are certain timelines for when you have to provide your records. And one of the biggest ones to note is that within 4 hours, if the Assistant Secretary asks a company, they have to provide their written plan. So our guidance is, we've already created some draft plans for folks to riff off of. We don't know if this is, this order is going to go back into effect this week, next month, or ever. But, given some of the tight turnaround times for when the Assistant Secretary could begin asking for some of these records, it might make sense just to have a plan in place. So the why. Enforcement and penalties. Why should you care about this? Well, there's some pretty serious consequences that come into play for non-compliance. OSHA has indicated that enforcement of the policy is largely going to be complaint-driven, and we do know that they're allocating additional resources to follow up on these complaints. It's going to be a complaint hotline. Folks who feel that their employer is not complying can call in, and that would trigger a site visit. Additionally, OSHA can conduct site visits on their own to just check up. They'll issue citations with varying penalties, the height of which is $14,000. My understanding from a Q&A that OSHA did with the White House, through the White House with reporters, is that that would be $14,000 per violation per day. Obviously it's far too soon to see how these are, going to be implemented, but OSHA has also indicated that, they're not going to be nitpicking through, technical violations. What they're looking for is good faith efforts to comply or bad faith efforts to not comply at all. Employees and employers would each also be subject to penalties, including fines and jail time for providing false information. So you falsify a vaccine record, you falsify a test, the employee could potentially face federal criminal penalties for that, as well as the employer if they allow that to be part of the record and provide that as part of the record. So we want to get into a pretty robust question and answer session here, and we've left a good bit of time for Q&A this morning because there is a lot to cover. I have gone through and collected a lot of your questions that you submitted over the weekend. Brett and Sandy, if you want to come back on, we can take a lot of these here. So the first question that we have seen is related to remote workers. Right, the COVID-19 pandemic has pushed so many of us into the remote workspace, and we got so many questions about what about workers who are completely remote? They never come into the office. Do they count towards the 100 employee total? Am I even covered by this ETS if all my workers are remote? And second, do they have to be vaccinated or tested? I'm going to toss that one over to Brett and allow him to answer.
So when you are counting employees to determine whether you even fall under this ETS, you do count remote workers, whether or not they're working at home or in a coffee shop or in the office or on the assembly line, they get counted. When it comes down to whether they are covered, whether they have to comply with the mandate or the testing option, they do not. If you are fully remote, if you are not ever coming into contact with either fellow workers or members of the public, OSHA has said that you are not required to comply with the vaccine mandate or the testing and masking.
Great, thanks, Brett. Our second question relates to, sorry, just a second. If the company can, how the company decides on testing. Can the company decide what type of test is acceptable? And if so, do employees have to prove that the test is theirs, right? We're all familiar with these take-home tests, and we're considering putting these testing protocols in place. What does it mean, when these employees can just do a take-home test? How can we trust that that is accurate? Sandy, do you want to answer that one?
Sure. Yep, we got this question a lot before the webinar, and I'm seeing it a lot in the chat. So this is a big deal for sure. So, right, can the company decide what kind of test, right? Can Miller Johnson say, Sandy, you need to get X, Y, Z kind of test? And to a certain extent, yes, right? Both the point of care and the over-the-counter tests are acceptable under the ETS. But remember, the administration of those types of tests are a little bit different, right? The ETS specifically talks about to be a valid test under the standard, a test cannot be both self-administered and self-read unless it's observed by the employer or an authorized telehealth proctor. So what does that mean, right? So the take-home tests are okay, right? I can administer it myself, but somebody else has to read it. I can't be administering it to Sandy, and Sandy can't be the one to read it. So, right, that independent confirmation piece is really important, and that can be accomplished in a couple of different ways, right? You can involve a licensed healthcare provider or a point of care test provider. If it's an over-the-counter type of test, it can be used as long as it's administered in accordance with those instructions. The employer can validate the test through the use of a proctor test that's supervised by the employer or an authorized telehealth provider. So Alternatively, right, the employer can obviously proctor and over-the-counter test themselves, right, in the event that you want to get in the business of doing that. So the ability to kind of pick your type of test is somewhat broad, but remember, it can't be both self-administered and self-read. So we saw a lot of questions in the chat saying, right, can my employee just do the home test and, right, take the screen, right, all of that, right, and tell me it was positive or negative. So that's the important piece to keep in our head. Can't be both self-administered and self-read. So we've got to figure out a way to bring those pieces together.
Great, thanks, Sandy. And for those of you who had a lot of questions about those, if you have additional follow-up questions that are specific to your workplace, feel free to put it in the chat, or you can follow up, with your Miller Johnson attorney with a specific question on that. Another question that we got pretty frequently is, how do these rules apply to unionized workplaces? This is really important to keep in mind, because even though the ETS is mandatory, there has to be a vaccination policy or a testing policy in place. There are discretionary components here that are subject to collective bargaining. So, Brett, why don't you jump in and take that one?
Sure, Hillary, and she's exactly right. There's another wrinkle here if you have at least a somewhat unionized workforce, because even though having a union doesn't get you out of any of the requirements that OSHA is putting forward, it does mean that for all the discretionary components, these are topics on which you need to bargain, and so you need to make sure the union is aware that this is coming and see if they want to bargain over anything. And just as an example, some of these discretionary pieces would be how a testing regime would work, who covers the costs, for masks, how does paid time off work for masking for testing and or vaccination. So you needed to take into account that the NLRA imposes obligations on here that are not swallowed up by the fact that you're complying with an ETS from OSHA.
Thanks, Brett. Number 4, if employees receive an exemption based on a reasonable accommodation of a sincerely held religious belief, do they still have to test weekly? Sandy, you want to take that one?
Yep, sure can. The answer is yes, right? So remember, it's any unvaccinated employee, right, of a covered employer, and it's not somebody who's working exclusively outside, somebody who's not remote, right, somebody who's reporting to a workplace with other people, right? If the employer is covered and the employee themselves doesn't fall into one of those types of exemptions, everybody has to be vaccinated, unless, right, and for any employee who's not vaccinated, they are subject to testing, regardless of the reason. So if you're an employer who's choosing the mandatory vaccination policy, right, there's only 4 reasons an employee could say, nope, I'm not going to get vaccinated. And yes, absolutely, those employees would need to be tested. If you're doing a partial vaccination policy and the employee can choose, right, hey, employees, we have a vaccination policy, and the employees can choose, nope, I don't want to. They don't have to fall into a specific type of exemption. They have to get tested. So moral of the story, right, is whatever the reason, if you work for a covered employer and you are a covered employee, if you are not vaccinated, you are subject to mandatory testing. So whether that be for a reasonable accommodation under the ADA or a reasonable accommodation under Title VII for a sincerely held religious belief, right, if vaccination, if you fall into one of those categories, testing is absolutely required. Now, I see some questions in here related to, can an employee be exempt from testing? Can somebody get a reasonable accommodation for testing, right? And so what we always say is, right, that's a request for a reasonable accommodation to our existing reasonable accommodation. And you would just go through the continuing analysis, right? You go through the analysis and the guidance that the EEOC has related to how employers evaluate and provide for reasonable accommodations when employees have objections to vaccination or testing or any other policy you might have in the workplace, really something that inhibits their ability to of their sincerely held religious belief or their disability.
Thanks, Sandy. That's really helpful. And I also just wanted to give a plug for a podcast that we have that is coming up on Wednesday, which is directly going to be covering the exemption piece of this. And if we were talking as a group, if we continue to get a lot of questions around this, we may also consider doing a separate webinar as well, to the extent that that's helpful. But Rebecca Strauss and Sarah Willey are going to be covering that. Amy, if you are on and you happen to have a link to that and you want to drop it in the chat, that would be great. So question number 5, and we're getting a lot of these in the chat. You all are anticipating the questions that we've received to date as well. Do I have to provide my employee with paid time off if they are removed from the workplace due to COVID? Brett, you want to take that one?
Yeah, this is pretty easy. On the one hand, no, you don't have to. On the other hand, they certainly need to get any leave they would otherwise be entitled to, but you don't have to. And then I will add, you certainly can. And in reference to my previous answer about those of you with unionized workplaces, I mean, something you work out with the union could also cover this topic. And that would be something that might be bargained about. But no, you are not required to under this ETS, as long as you're giving your employees the regular leave that they are entitled to under normal leave policy.
Great, thanks, Brett. Sandy, can you talk about what implication this rule might have for public sector employees, schools, and if you can incorporate into that, we've seen a lot of schools too, folks ask about private schools as well, but the public sector piece and then the schools, especially here in Michigan.
Yeah, so this is really important, right? So remember, right, everybody on the call, remember who the OSHA Act just generally doesn't apply to, right? You guys all think about this all night long. So generally, right, the OSHA Act doesn't apply to state or local government employers and employees. They're usually exempt from coverage unless they're in a state with a state plan that folds in that coverage. So long story short, here in Michigan, as you know, we have an OSHA-approved state plan, the MyOSHA Act, and under the MyOSHA Act, state and local government employers and employees are covered. So here in Michigan, the answer is yes, right? Those public entities would be covered under whatever rule, which it sounds like we think it's going to be verbatim to the ETS, whatever rule MyOSHA adopts. But for those of you who have employees or you're an employer in another state, it's really important for you to evaluate, one, if that state has its own state plan and what the coverage is of that state plan. So that's an important piece, right? Recognize where you have employees. The second piece of that is related to, right, private institutions, schools, for example. So going back to, right, let's think about the 10,000-foot view of the OSHA Act and the MyOSHA Act. If you are a workplace covered by the OSHA Act or MyOSHA Act, unless you are specifically exempted from any of the standards, those standards apply to you. So as we look at this particular ETS, there is not a carve-out, right, for certain types of private institutions like private schools, right? You still have to hit the 100 threshold, and for an employee to be covered, right, they have to not be remote and have to not be working exclusively all outside. You do all of that same type of analysis, but unless you're specifically exempted, this ETS does apply to you.
Thanks, Sandy. And then I've seen a number of questions related to the face coverings. When do they have to wear them? Are there any exceptions to that? And I'm just going to answer that one. The rule itself discusses this in pretty big detail. This is under Section I of the rule, face coverings. For those who have an actual copy of the rule, maybe in front of you, it's on 61553 of the Federal Register, and it says, the employer must ensure that each employee who is not fully vaccinated wears a face covering when indoors and when occupying a vehicle with another person for work purposes. except when an employee is alone in a room with floor-to-ceiling walls and a closed door. So if you have a separate office, not a cubicle, but floor-to-ceiling walls, that non-vaccinated employees does not have to wear their mask in their own office. For a limited time when an employee is eating or drinking at the workplace, or for identification purposes in compliance with safety and security requirements. When an employee is wearing a respirator or a face mask, where the employee can show that the use of face coverings is infeasible or creates greater hazard that would excuse compliance from this paragraph, like when it's important to see the employee's mouth for reasons related to their job duties, or when the employee presents a risk of serious injury or death for the employee for some reason. So the employer also has to ensure that any face coverings required by this section is fully compliant, has to cover the nose and the mouth, and that it gets replaced when it's wet or soiled. So if you have your employees working in an industry that, where the mask is going to get dirty frequently, you have to provide those, you have to make sure, rather, the employer does not have to provide them, but has to make sure that they're not wearing those soiled masks. So employer must not prevent any employee from voluntarily wearing a face covering. This is important and something we're seeing in a lot of workplaces, but can't prevent the employee from voluntarily wearing a face covering or face mask unless the employer can demonstrate that doing so would create a hazard of serious injury or death, such as interfering with safe operation of equipment, et cetera. So, those are some of the pretty frequent questions that we have been getting around face coverings. And, again, if you have, as you're putting your policies into place, if you have additional questions on those, you can feel free to reach out specifically. I'm scrolling through here to see the updated questions that we've gotten in response since they've been coming in. I feel like we've covered a lot of these so far. A lot of remote workers.
Hillary, can I talk about the 100 employee thing in terms of more complicated corporate arrangements? Because I'm seeing a lot of questions on that, and I don't think on this call we can necessarily give you a definitive answer, but I can tell you what we do know, and if you have further questions that are not answered, please contact your attorney. The rule does not go into a lot of detail about when you can combine affiliates and whatnot. They talk about corporate entities, and does that entity have 100 employees, as you count, as I discussed earlier. What it does say, and I think this is as far as I can give you on this webinar, and again, we can research further if we need to for, I know, all of your different situations, but it does say that if related entities jointly regulate health and safety across the multiple entities, that OSHA will likely integrate them for purposes of this rule. I assume that their thinking here is that means that there is an HR apparatus sufficiently robust that could handle the implementation. So that's all that we can tell you at this point. But so if you have, different entities that are not technically the same one, but you act as a single entity for purposes of how you regulate health and safety, then this does cover you, assuming that the numbers hit over 100 if you combine those entities. Thanks, Hillary.
Thanks, Brett. Great. We've also been getting a lot of questions on proof of vaccinations. Sandy, do you want to sort of just provide some further clarification on that? What is what are standards of proof, et cetera?
Sure. So we had a couple questions, right? How do we verify proof? I assume we just ask, and what if an employee doesn't want to answer, right? So importantly, if an employee doesn't provide the specific list of acceptable types of proof, the employer must assume that that individual is not fully vaccinated, and so then must put them through the testing protocol, the testing and face mask protocol, right? So absent an employee providing you proof, you assume they're not fully vaccinated, okay? So the ETS lists very specific types of acceptable proof. One is a record of the immunization from a healthcare provider or a pharmacy. You can also get a copy of the COVID-19 vaccination record card, right, that CDC card. An employee can submit to you a copy of their medical record documenting vaccination. They can provide you a copy of their immunization records from public health, right, if their MICR record or something like that, if we're talking about here in Michigan, or a copy of any other type of official documentation that contains the type of vaccine administered, the type, the date or dates of administration, the name of the healthcare professional or clinical site administering the vaccine. Now, right, so we're all of these months in, and you have an employee who says, I did have that, I can't find it, right, all of those things, that's going to happen. The ETS contemplates that, helpfully, right? And so OSHA has said, yeah, employers, you can accept a signed and dated employee attestation that can be acceptable in instances where an employee is unable to locate any of the other forms of acceptable proof, right? But again, if they can't or won't provide that proof to you, you have to presume that they're not fully vaccinated and put them through the testing protocol. Now, the next question, I'm not even sure if we've gotten it, but I'm sure we will, because it occurred to me as I was reading it, well, what about all of the employers who were checking vaccination status for the last several months because they had their own policy or own protocol, and maybe it wasn't one of these types of things? Again, helpfully, OSHA anticipated that and had a particularly helpful answer, I think, an employer-friendly answer that says where an employer has ascertained employee vaccination status prior to the effective date of the ETS, so before November 5th, if you've done it through another form of attestation or proof and you have retained those records, the employer is exempt from making sure it's one of those 5 specifically articulated types of proof, as long as you maintain the record just as you normally would, right? That's required under this ETS. So that's fantastic news, right? You had an existing policy and you were already collecting that information through asking employers to prove it to you or attest to you. Sandy says, yes, I'm vaccinated, or Sandy says, no, she's not vaccinated. If an employer has asked that question and has kept that record, the employer can use that if it happened prior to November 5th. So November 5th is the cutoff day, right? If you're doing it before then, you can do attestation or proof in whatever method was appropriate. If after that day, it's got to be one of those 5 articulated types of proof. But if an employee doesn't have it, they can do an attestation.
That's great, Sandy. Thank you. Thank you so much. And I apologize, my sound was going out just a little bit. I apologize if you said this, but I saw somebody ask about the booster, if that was included, and I apologize if you said that, but the ETS does not require the booster to be fully compliant with the vaccine. So to be fully vaccinated simply means to have the complete recommended dose of any one of the approved Pfizer, Moderna, Johnson & Johnson, so either the 2 shots for Pfizer and Moderna or the 1 for Johnson & Johnson, and then you are fully vaccinated 2 weeks after that. The frequent follow-up question that we had in our office was, well, do you still have to do the testing during that period? You know, that's about a 5 to 6 week period, and the answer is yes. So if an individual is, not vaccinated by that January 6th date, then yes, they have to begin the testing protocol at that time until that is in place. So someone asked about, if someone doesn't want to comply with the testing or the vaccination, is termination the recommended outcome? The OSHA guidance, the ETS does not provide for, a separate basis for termination simply because of noncompliance. However, it would not be an actionable offense specifically under this ETS, and there is some additional guidance in the rule on that. So, you know, that is essentially an employer's decision at that particular time. We've put in the chat the link to the OSHA FAQs, which are pretty extensive and pretty helpful. And, you know, again, your Miller-Johnson attorney is just a phone call away if the answer is not there that you seek. And, you know, our government affairs practice group has some great contacts at OSHA and the Federal Department of Labor that we can use to get your questions answered if they're not here. We're going to take one more question, and then, you know, before we let you go, we do have an action list of things that you should still do today, even as we wait in this strange purgatory of the ETS. And that question is on the interplay between this and COVID ERA. And I'm going to let Sandy take that one.
Yeah, so whoever asked this question in the chat, we'd like to offer you a job here at Miller-Johnson for issue spotting that issue. So remember, here in Michigan and in several other states, there are similar types of laws. Right here in Michigan, we have what's called the COVID-19 Employment Rights Act, or it's also called PA 238, where it requires an individual not to report to work under certain circumstances. 1, if they've tested positive; 2, if they're symptomatic; 3, if they're close contact but not fully vaccinated, so on and so forth. So this OSHA ETS does nothing to diminish the Michigan's COVID-19 ERA. Certainly, when you've got unvaccinated folks who are testing so frequently, right, you might get a positive test, and that's your notification as an employer that that employee needs to stay removed, right, under OSHA and under the Michigan COVID-19 ERA. But remember, the Michigan COVID-19 ERA does not have a sunset, so it is not linked to the OSHA ETS in any way. It is law until it is repealed. And so it was here before the OSHA ETS. It may be with us much longer than that, but it's really important to remember that that still exists, and employees and employers have obligations under that law.
Thanks, Sandy. That's really helpful. So here's what we think you should do today. Immediately send communication to employees on the current state of the ETS, as well as get in touch with decision makers to let them know what's happening, right? There's been a lot in the news, and few people have taken as much time as you all on this webinar to listen and understand what is really happening. You know, some people know this big rule was coming. Fewer know that it actually was implemented. Even fewer know that the Fifth Circuit acted over the weekend to temporarily halt that and what that means. So, you know, again, information is power. Spread that information to your workplace. Let them know that you are in control of this information and you're monitoring it, and you're going to update them as we update you. For unionized companies, send communication about the ETS and the components of which are subject to collective bargaining. We think that you should form an accommodation request committee. We know that these accommodations are coming, and you need to have a plan in place for how you're going to deal with it. And finally, decision makers at your organization need to decide if you are going to implement a plan right now, and if so, start making sure that you know what that plan is going to be. If no, decide if and when you're going to act. What's going to be the trigger point for you when that happens? So our contact information is here at the end. Oops, I'm sorry about that. And we will leave that all up for you. I know Sandy, Brett, and I have all made ourselves available to answer any follow-up questions that you might have, and we'll do our best to get back to you in a very timely manner. I've left time available today knowing that there will be follow-up questions. This was a 500-page preamble and rule that was issued just last week, and almost immediately the Department of Labor realized there were some holes to fill in. So Even if we don't have an answer yet because it's not clear, we'll work to get that answer for you. Thank you all so much for joining today, and we are still collecting the answers that you have, or the questions that you're putting here in the chat. But thank you again for your time, and have a wonderful day.
Thanks, everybody.